Hey there! So here's the thing about PHI. It's your responsibility as a county employee to make sure you understand the rules around when you can and can't disclose an individual's protected health information. It's important for you to know that individuals have a right to authorize the use and disclosure of their PHI. But this is often a misunderstood subject, and this training is designed to help you understand some key concepts related to authorizations. Of course, there's much more to this subject than we can cover here, so please be sure to check with your department's policies and procedures for more detailed information. So let's get started. At its most basic form, an authorization is either a written or verbal permission to disclose PHI to a third party. An authorization is also called a release of information, and an individual under HIPAA cannot usually be required to sign one to disclose information about themselves. They should be voluntarily and freely given by the individual. Check your department's policies and procedures for instances when an individual is required to sign an authorization or a request to access form. It is your responsibility to understand when an authorization is needed and when one is not needed to disclose PHI. In many situations, an authorization is not required to disclose PHI. These situations include, but are not limited to, disclosing information to another provider for the purpose of treatment. It's okay to disclose information to insurers and payers of a healthcare claim such as Health Share of Oregon or Oregon Health Plan. And one exception here is that if the disclosure includes substance use treatment or referral, you will have to obtain an authorization. Disclosing information without an authorization is also okay when it lessens a serious and imminent threat of harm or is a mandatory report of child or elder abuse. An authorization is not required when disclosing information to a third party that performs services on our behalf, such as a business associate. Some examples of when it is appropriate to require an authorization would be, but not limited to, disclosing information to a family member or friend, disclosing information to a parole or probation officer when not required by a court order, disclosing information to a media outlet for the purposes of publicity, like the county sharing an individual's compelling story. Last but not least, individuals have a right to access their own PHI, so an authorization is not required to give someone their own personal health information. So now you know what an authorization is, and have some examples of when it is and isn't required. But it is important to know if the authorization is even valid. Written authorizations must include specific elements to comply with HIPAA. There are hundreds of different authorization formats out there, so use what you learn here for any document you receive. The county does not require a third party to present our form, so you are responsible to make sure all elements are included before you disclose any PHI. There are three main parties that must always be listed on a written authorization. The entity disclosing holds the information that will be disclosed. The entity receiving will receive the information. Finally, the individual whose information is being disclosed. The receiver of this authorization must be able to identify the individual named, so a written authorization usually includes multiple unique identifiers, like a name, date of birth, or medical record number. Remember, when assisting an individual who is filling out a written authorization, avoid asking them to put their full Social Security number on the authorization. Written authorizations must always have an expiration date. They cannot be indefinite. Generally speaking, 1 to 2 years is recommended. A valid written authorization specifically describes the information to be disclosed and the purpose of the disclosure, like for a life insurance application. Don't leave anything to assumption. If it isn't listed, it can't be disclosed. If assisting someone, asking them, "What information can I share with your family or friends?" can be helpful for completing a written authorization. Remember to be specific. At the end of a valid authorization is the individual's signature or personal representative signature, if applicable, which can be a parent of a minor child. All of these elements are included on Commons, or check with your designated privacy manager or coordinator in your department. If the authorization does not include all of the required elements or doesn't list Multnomah County as the disclosing or receiving entity, it is your responsibility to notify the requester of what information is needed to make the authorization valid. If for some reason a third party refuses an authorization on the county's standard form, ask why and contact your privacy manager or coordinator for additional assistance. Not all authorizations need to be written. A verbal authorization that is limited in scope and duration is acceptable to disclose PHI to a recipient. These cannot involve substance abuse treatment. Be sure to thoroughly document in the record what permission was given and what was disclosed. You've got the authorization in front of you. It's valid. Now, what can you disclose? Remember, before you disclose anything, be absolutely sure you are referring to the right individual's information. For example, if you receive a request to disclose Jane Doe's records, and when you look Jane up you find there are 5 other Jane Does, you will need another piece of information to verify you're referring to the right individual. It's best to find 2 to 3 unique identifiers, like a date of birth and medical record number, to be certain about the individual's identity. Whether the authorization is in writing or verbal, you can only disclose information within the scope of authorization given. For example, this form authorizes the county to disclose Jane's diabetes treatment to Amy, but Amy calls and asks about Jane's recent sinus infection. However, under this authorization, Amy is only permitted to know about Jane's diabetes. You could contact Jane and ask for verbal authorization, or send Jane a blank authorization form to expand permitted disclosures. But until then, you cannot disclose the sinus infection information because Amy does not have authorization to receive this information. This is important. A signed authorization is a permissible but not required disclosure. This means if something doesn't seem right, or there's a suspicion of abuse to the individual named, you should use your judgment and not disclose information. If you have questions, talk to your supervisor or manager, your department privacy manager or coordinator, or the county privacy officer. After you've disclosed information, follow your department's procedure for documenting disclosures in the individual's record. An individual may revoke an authorization in writing so that future disclosures cannot be made. Notate the date and notify others that work with the individual so they are aware. You're ready to take what you've learned into your everyday. Just remember, when in doubt, ask. If you're unsure whether to disclose information under an authorization, talk to your supervisor, department privacy leader, or email privacy@multco.us. You can also report privacy and security incidents to those same individuals, or make a report by calling 888-289-6839. For more information, please visit the Commons page at commons.multco.us/HIPAA-privacy. Thank you.